Wow. Good morning, everyone. It's nice to see a full house on our last day of sittings for the term. I know we have a group from, I think, Catholic University Law School. Welcome to all of you, but I have a feeling we have more than that. But welcome to everyone to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar, and we'll get started with the first one, which is number 24 CF 234. RAVEL Mills versus United States. Ms. Terrell, whenever you're ready.
May it please the court, Fleming Terrell on behalf of RAVEL Mills. I'd like to reserve 2 minutes of my time for rebuttal. The trial court doubly abused its discretion in this case. First, in concluding that the defense opened the door to previously excluded evidence of Mr. Mills' claimed past acts of violence. And second, regardless of whether the door was opened, in letting through that door, what the court itself recognized was unbelievably prejudicial evidence that those claimed acts included shooting a man over a disagreement, just like the crime for which Mr. Mills was on trial. And not only that, but also that it was the same man that Mr. Mills claimed to have shot over the same disagreement that the government presented as the motive for the charged shooting. This created an intractable risk that the jury would draw impermissible propensity inferences, not only that Mr. Mills was a violent person, but also that he was the sort of person who resolves his disagreements with gunfire, just as charged in this case, and that he had a specific propensity and motive to shoot the decedent in particular, the exact use for which this evidence had been excluded prior to trial. And the prosecution used it for that purpose in its closing argument, describing not just a beef that was based on words, but one that escalated to a fistfight and then to Mr. Mills allegedly shooting at the decedent, to give the jury a far more convincing theory of motive for what was otherwise an inexplicable killing following a chance encounter between Mr. Mills and the decedent. The wrongly admitted evidence, thus, shored up the key weakness in the prosecution's case. And it's therefore impossible to say with any assurance, much less that it was highly probable, that the fistfight and shooting evidence did not contribute to the verdict in this case.
Terrell, can I interrupt by asking you, there's a lot going on in this case, but a lot goes back to Judge Epstein's kind of ruling about this evidence and the remoteness and how it's not substantiated. How much are you relying on that, as still established, even toward the end of trial when closing argument is happening and instructions are happening? The government is arguing that things change and that balance changes. Can you talk a little bit about the extent to which that ruling kind of carries through?
Sure, and I think the ruling absolutely carries through. The trial court never stepped back from Judge Epstein's ruling that the evidence of the claimed prior violent acts were inadmissible for the purpose of proving motive.
Well, it's very interesting in your answer, if you could also comment upon the conversation the judge has with Judge Epstein, which is very odd. And it seems to carry with it a permission to scale back the ruling or something. I'm not sure how to consider that.
There was a dispute between the parties on what to make of Judge Epstein's ruling, whether it related to the evidence of the disagreement, the beef as a whole, or only to the other crimes embedded within that evidence, so the prior fist fight and the shooting and the gun possession. The defense maintained that it was the whole thing, and that is what Judge O'Keefe sort of tended to disagree with when it checked with Judge Epstein, who confirmed that, no, I was just looking at other crimes evidence. I didn't make a ruling on the motive, the beef itself. And that's when,
Procedurally, though, sorry to interrupt. I don't know, does PDS have a position? Does Mr. Mills have a position as to whether that was procedurally correct? I don't know that I've seen that before. I mean, it seems like there should really only be one trial judge at a time. So, and I saw that defense counsel was saying, please send this back to Judge Epstein to resolve this dispute. That was rejected, and the compromise position seems to have been that Judge O'Keefe would consult with Judge Epstein and they would work it out between the two of them. That seems unusual, to say the least.
Yes, I agree it is unusual. And I think Judge Epstein's ruling was sound and should have stood. And I think
We get to decide what the scope of that ruling was.
I think that's right.
Okay.
And I think Judge O'Keefe began to realize as trial went on that perhaps it remained the case that the evidence was too slim and that these alleged events were too remote in time and too poorly substantiated for even the existence of a beef to come in.
That's my follow-up question, but then I don't want to divert you from Judge Beckwith's question, which is Mr. Mills challenging the admission of we need a vocabulary for this case, like the scaled back, just there was a beef between Mr. Mills and the neighbor testimony. Is Mr. Mills saying that shouldn't have even come in, or is Mr. Mills sort of living with that and really just challenging the admission of he had a gun, he exchanged gunfire evidence?
We think the beef itself, and I am happy for the court to disagree with me on this point. We think just the very slimmest of margins was there sufficient evidence to connect the man with dreads to the decedent. I think it's debatable whether.
What evidence do you think that was?
The only evidence that the prosecution admitted, and that came in after Judge O'Keefe said, maybe I made a mistake with this ruling about the beef evidence, was to put on the decedent's grandmother, who testified that she had
visited
her
once.
She'd been to the house once
and picked him up
and had picked him up some number of times over the preceding many years, and that he had a girlfriend in the neighborhood, and that the decedent was next to that house when the encounter began. That was all.
What do you make of the fact that Mr. Mills himself, on cross-examination, implicitly supported the notion that his beef was with the decedent when the prosecutor questioned him and there was no objection by the defense?
Well, that questioning would not have come in but for the erroneous ruling that we've focused on here on appeal.
Well, is that right? I mean, the erroneous ruling you focused on, I thought, was the ruling that the question to Miss Robinson, would you say he was harmless, opened the door to questioning her about information she had received that he was not harmless. I don't think that opened the door, and she didn't say anything about she did not identify the person he had a beef with as being the decedent.
That's correct.
So then, this is what's puzzled me about this case, and I fear as if I don't know the record as well as you do. Then when Mr. Mills gets on the stand, the government questions him about that and makes a pretty decent implication that the decedent and the person he had a beef with were the same person. And there's no objection to that at all by the defense, even though it would seem as if this was going against Judge Epstein's, prior ruling. That's what's puzzled me about this case. And then in closing argument, in rebuttal, when the government makes the argument that the motive, ladies and gentlemen, is that he was motivated, and you know that because of that prior beef, there's no objection to that closing argument either by the defense. That's what's puzzled me about this case. Why should we treat this argument as preserved under those circumstances?
I think as for the closing argument, while the defense didn't object mid-argument, it got up and corrected tried to correct for the jury the limited purpose for which that evidence could be used, because the government had misstated it in its closing argument. But I don't think there's any question that the defense amply preserved its argument that the entire claim of a beef and all of the violent acts it entailed were far too remote in time, far too insubstantiated to be used as motive evidence.
I would have thought that, as I say, if there had been an objection to the government's.
Well, at that
Yeah.
point, Your Honor, we had raised it in limine pre-trial. There had been a fair bit of litigation about it, and we had lost. Judge O'Keefe had ruled that the existence of the beef comes in, and just to clarify on the
But
record.
see, maybe I misunderstand this case. I understand that what Epstein had ruled. He said it doesn't come in. Okay. But then we have a trial. It's coming in through some information about it is coming in through Mrs. Robinson, through her examination, but not for the purpose of showing motive. It's only for the purpose of showing that Mrs. Robinson doesn't have a good basis for saying he's harmless. And it's only later, I thought, when the power of this thing expands into, and this is motive evidence.
Let me go through sort of the testimony that came in, because that may be helpful. On her direct examination, the government elicited the existence of the beef, the claimed existence of the beef from Ms. Robinson, elicited that Mr. Mills had told her that he had a disagreement with his next door neighbor with dreads. The defense, in cross-examining her, did a few things. Having lost the argument that the mere existence of the beef shouldn't come in, right? Challenged her certainty that the person, about who he was talking about, right? Said, it could have been 2 doors down. You don't know who it was. This is who you thought he was talking about. And you also can't say that that's the decedent, right? And
can I stop you there? And
Yes.
that's why it didn't really go to motive at that point. It only went to whether she had a basis for saying he was harmless.
The prosecution had elicited on her direct the existence of this beef to establish a motive. And that's how they used it in their closing argument, right? To establish that there's some reason why in this chance encounter, Mr. Mills would develop an intent to kill the person that they identified as the decedent. And then the defense is trying to respond to that by saying, you're not even sure who he was talking about. After the cross-examination, the government gets up and says the defense has opened the door. And the first thing they say is that they've opened the door by these questions about memory, about how well she remembers this conversation. We should be allowed to get into these details. Ultimately, the court considers—
They had a better argument than that one.
Ultimately, the court considers several door opening arguments, and I have things to say about why the court got it very wrong on that. But the court says, actually, the door's wide open. I'm going to allow everything now that had been excluded. So there was no question up to this point that the government could not elicit that there had been a fist fight, that there had been a shooting, any of those prior violent acts, because that was other crimes evidence that's highly prejudicial, right? And Judge O'Keefe said, all of that comes in now, and I'll let the Court of Appeals sort out who's right about this. And then the prosecution on redirect elicited from Ms. Robinson all that Mr. Mills had allegedly told her about this dispute, how it started, that it was over an insult, where it started, the fist fight, the shooting back and forth. And indeed, they were so focused on connecting that evidence of prior violent acts to this theory that they had of motive based on a beef, that when she expressed some uncertainty about who it was that he had told her he had punched and fought with, they impeached her with her grand jury testimony where she had said it was the man with dreads next door. They are the ones who made that connection. And Judge O'Keefe had said explicitly that evidence comes in. And so then later in the trial, when Mr. Mills testifies, the only thing he testifies on direct is that he had no beef with the decedent. That's all. On cross-examination, the government cross-examined him saying, did you tell Ms. Robinson all these things that she told us you said. And he basically said, yeah, whatever she says, I said, I'm sure I said it. The defense would have been hopping up and down objecting to that line of questioning had the evidence not already come in through Ms. Robinson. So I don't think there's any, sort of for purposes of
They
assessing.
go further. They say it was, and your beef was with somebody who lived in this house, whatever it was. And
All he said.
And they identify, and by process of elimination, as it were, they identify the person he had the beef with as probably being the decedent who lived in that house rather than the decedent's father.
Well, that was the prosecution's position, but Ms. Robinson testified on cross-examination that there was more than one person in that house with dreads, and there was no evidence. There was this sort of anemic, slender reed of evidence from the grandmother that sometimes the decedent had been at that house.
My point was only this was where the government finally says, here's evidence that you can consider in determining that his beef was with the decedent, because he admits that he had a beef with somebody who lived in that house. The father lived in that house, the decedent lived in that house, and it wasn't the father.
So no, I don't think that's right, Your Honor. I think already whom the beef was with had come out through Ms. Robinson because of this door opening ruling. So that was not new in Mr. Mills's cross-examination. And to be clear, he did not testify that in fact he had a beef with someone in that house. He did not testify that in fact it had involved any prior shooting or fist fight. He was asked, did you tell her about some beefs you had? And he said, I told her about one beef. I told her about one beef. He did not testify that really I did have a beef with this person. Right. And I think that is important because, the very narrow, limited reason Judge O'Keefe allowed this testimony in was not to establish motive. That ruling stayed in place, that the prior violent acts could not be used to show motive, was only to test the reliability of Ms. Robinson's purported opinion that Mr. Mills was a peaceful, nonviolent person.
Why didn't the defense object to the rebuttal argument by the prosecutor?
Well, instead of objecting, we attempted to correct it. And at that point, we had lost and lost and lost again about what could be admitted. I agree that the prosecution did use it impermissibly, but again, that wouldn't have been possible without the erroneous ruling that we're complaining of. I think it certainly exacerbated the harm. The way that it was used in closing really goes to show.
I mean, once again, which exactly is the erroneous ruling that you say you complained of?
The ruling, the abuse of discretion that we think is at the heart of this case is the decision to allow, leaving aside whether the door was open to the prior crimes evidence, which we think was also incorrect. The trial court completely failed to carry out its heavy responsibility to screen and sanitize what comes through the open door.
Well, what's the ruling that you
The
claim?
ruling is the decision that the evidence of the claim of prior violent acts, the claim of a fist fight, the claim of shooting over this dispute with the same person comes in to rebut Ms. Robinson's purported character testimony.
But see, I thought that ruling was okay because the door had been opened to show that she had been told certain things by the defendant that undercut her claim that he was harmless, her opinion that he was harmless.
Well, I don't think she was offering an opinion that he was. I think the testimony that he was harmless did not open the door because it was clearly part of this colloquy about whether he's a jokester, which went to the defense theory of why he was on video following.
So that's a different argument. So you're arguing now, if I understand correctly, that when she testified, when the defense asked her, and in your view, he was harmless, right? Some words to that effect. And she said, and she agreed with that. You're saying that did not open the door to the government to impeach that opinion?
Absolutely. Yes, we are saying that.
I don't understand that. I don't understand why it didn't open the door to impeach that opinion.
Because although while taken out of context, like some of the testimony in Becton, when taken out of context, it may sound, he is harmless, may sound like an opinion on his peaceful character. When viewed in context as it must be, It's clear that it was not suggesting to the jury that Mr. Mills couldn't have committed this offense, this charged offense, because he's not the sort of person who would ever commit a violent act.
But is the question what the jury would have understood or might have understood, or what was intended?
I think the question is, I mean, I think both are relevant. Ultimately, I think it's what is conveyed in the testimony. And I think it's important in that regard that neither the trial court nor the prosecutor, throughout all of the lengthy colloquy about door opening that followed the cross-examination or in the written pleadings that followed, identified this question about harmless. And that's, I think, because it was clearly in context, sort of an idiomatic way of saying, you think he's a jokester, right? It
I
came.
think our standard of review is abuse of discretion for opening the door. Do you think it's a de novo review question as to whether or not something constitutes character evidence?
I think on whether the door was open and to what, it's clearly an abuse.
Actually, just on the whether the door was open is really my question.
So whether the door was open to rebuttal, I think is,
it seems like to what is a discretionary question. That our law seems much more clear on that. But whether or not he was harmless is eliciting character evidence or factual evidence of your interaction with him. It seems like potentially a different question, potentially a legal question.
yes, I think it is. I think it is a legal question whether it constitutes character evidence. If we're looking at what was meant by that statement in context, I think this is not the same as a question of historical fact, like in a hearsay ruling, for example, where the court is making a finding that the declarant was excited, and this court's going to defer to that finding. This is really this is a question of what's in the record, and I would emphasize that the
Cite for that? I mean,
yeah. So we cite a case from Idaho RUP,
okay, but
that-
not from our court.
not from our. I don't think our court has opined on the question in the context of character evidence. The government relies on this footnote from Pitt. I really think that footnote is actually dictum because the majority in Pitt said the record amply supports the trial court's finding about what was meant, what was conveyed by the cross-examination to the jury. And sort of, by the way, in a footnote, we defer to factual findings. Looking at the briefing from Pitt, I don't think that was litigated.
We'll go back and look at it. I just had a couple of other questions. When you were talking to Judge Glickman about the court's ruling, I wonder if we could just ground ourselves in the record and if you could point us to where you think the court made the everything comes in ruling. I was thinking that you were talking about the colloquy with counsel on September 18th on page 13, but is there somewhere else that we should be looking?
Yes, I think it is most clearly at page 13, where he says that the question about harmless completely allows the government to get into, in fact, completely allows the government to get into the fact that by his own admission that he punched, allegedly, according to him, he punched the man with the dreads in the face, and that according to his own admission, both the man with the dreads and him shot at each other with guns.
There's even the sentence before. I think that certainly opens the door to get into the fact that as the defense opened on, that there's absolutely no dispute between Mr. Mills and the decedent. So it's even more.
Right, and those facts are not really pertinent to there's absolutely no dispute. I mean, that was a question of whether this beef was with the decedent or
I mean, there
not.
was this kind of, maybe schizophrenia is the wrong word, and I apologize, but the court seems to say you get to respond to this question of the inquiry whether or not Mr. Mills was harmless, or her characterization of him as harmless, but with evidence that sort of is much broader and seemingly not relevant to his harmless and seemingly more to motive. And yet you say Judge Epstein's motive ruling stood intact. So there's a little bit of tension there in my
Yes.
mind.
And I think the way we know his motive ruling stood intact is because, when they're arguing about the limiting instruction for this rebuttal evidence, the defense says again and again, please say that this can't be used for motive. And the court agrees that it can't be used for motive and ultimately gives a limiting instruction that it can only, at first it incorrectly instructs that it can be used for a character for violence, which is all but propensity, but by the end agrees that what it meant was that it was admitted to test the reliability of Ms. Robinson's testimony that he was harmless, not for any other purpose. So I don't think there's any question that the government should not have been using this for motive. Our argument is once the jury has heard that bell they can't help but consider it for motive. And that was only exacerbated by the way
that hardly justifies the failure to object when in closing argument, the government overtly uses it for motive. I mean, that's the perfect
Well, again,
opportunity to say, Your Honor, I want to correct the thing here. Tell the jury they can't.
rather than object in the heat of the closing argument, the defense counsel stood up and corrected the record, the jury, and said, you cannot use it for anything but to test the reliability.
The government made this preservation argument that
No.
Glickman is raising?
The government has not made this preservation argument. And again, what was in closing all just underscores the harm here. The problem was we already have evidence of a dispute with a next door neighbor coming in on exceedingly slender evidence to suggest it could be relevant. And then on top of that, based on a misinterpretation of the record with this, and I'll note also on the door opening question that the court wasn't making its decision based on demeanor or what kind of cadence there was to this examination. It was looking at the cold transcript is when it came to this ruling. Based on that, the court allowed in ultimately evidence that Mr. Mills claimed to have committed exactly the same type of offense, shooting someone over a dispute against exactly the same person over the same dispute that the government was citing for their motive. And I'll just note also that the trial court, Judge O'Keefe, had initially come up with a sanitized version of that testimony. Now, we think it was already wrong. So I suppose going to what we say is the erroneous ruling, it's sort of a two-part ruling, right? Because there's also the ruling on the 14th that the door has been opened to any of the prior violent act evidence whatsoever, right? We think that was erroneous. But what Judge O'Keefe landed on after that lengthy colloquy was that the government would be allowed to elicit only that Mr. Mills claimed to have previously possessed a gun and that he claimed to have previously been in a fight. And the government was okay with that. The government accepted that as sufficient to rebut whatever misimpression it thought had been created. It actually said in its pleadings over the weekend that it was only seeks to ask Ms. Robinson whether the defense ever told her he possessed a gun and whether he ever told her that he had been in a fight. The government would not elicit specific information about the fight at the Shipley Market or the shooting incidents that the defendant told her about. That's the government's sealed response to our motion to exclude that other crimes evidence. And despite that, inexplicably, Judge O'Keefe misread Romero to sort of say, mechanically, sort of automatically, once you've opened the door, everything comes through, which is exactly the opposite of what this court has said over and over and over again for decades. And sort of reversed course and without being asked said, all of the prior crimes evidence comes through without any attempt to exercise his heavy responsibility to sanitize that evidence, to weigh prejudice versus probative value. And, Awkward says that that's what's required. Romero said just a few years ago that that's what's required. And I think it's important that on appeal, the government has effectively conceded that identifying the target of these prior violent acts, saying that it was the same person with dreads that the prosecution identified as the decedent, had no probative value for rebutting or testing the reliability of Ms. Robinson's purported opinion that he had a character for nonviolence. And that is the most prejudicial aspect of the testimony that erroneously was admitted, because it linked those acts of prior violence, which already created a powerful propensity implication, to the specific beef that the government had presented as its motive theory. And I think that's why the
An
government.
objection at that point would have been helpful, wouldn't it?
Well, we did object. We had a lengthy colloquy about why this evidence was not admissible. We thought that the sort of scope of the court's ruling was about whether the sanitized testimony about, everybody thought, right? Sanitized testimony about possessing a gun and having been in a fight would come in. We made our objections that even that, A, the door wasn't open, and B, even that wasn't necessary, as this court requires, to rebut any unfair inference. And the court sort of went off in a different direction and said, you can do all of this. And once we sort of absorbed that, the defense came back with a motion for a mistrial and said, this is extraordinarily prejudicial. And that is when Judge O'Keefe said, I'm going to stand with it and let the Court of Appeals sort it out. So here we are. And I think the fact that the government fought so hard from pretrial through when it had this opportunity with the door opening to when it impeached Ms. Robinson on redirect to make sure that it confirmed that she was saying these prior violent acts were against the same person with dreads next door that the prosecution said was the decedent, that shows how very important the prosecution assessed this evidence to be to its own case. That's how it used it in closing, right? It described to the jury a dispute, a motive in the form of a dispute that escalated from words to Mr. Mills punching the decedent in the face to Mr. Mills shooting the decedent, just as he was charged with doing in this case. And that alone, I think, is reversible error. The second detail that clearly should not have come in, even if Judge O'Keefe was right about the door opening, is that there was a shooting, because that was shooting over a disagreement, right? That was so similar to the charged offense. Judge O'Keefe himself recognized that it was, quote, unbelievably prejudicial and, quote, extremely prejudicial. That's consistent with this court's opinions that evidence of similar crimes is especially prejudicial because it amplifies the propensity inference. And we think that
That's why it was a big mistake to ask Ms. Robinson, in effect, whether she thought he was a peaceful person.
I'm sorry, Your Honor, I didn't.
That's why it was such a big mistake for the defense to ask Ms. Robinson. Was this one question too many? Whether she thought he was a peaceful person?
Didn't ask her that.
A harmless. Well, if you think if you think everything turns on the difference between harmless and peaceful, that strikes me as a tough sell.
No, Your Honor, I think harmless has to be read in context, just as in Becton, this court read testimony that the decedent in that murder trial had been nonviolent, which in context looked like evidence of his character for peacefulness. Out of context looked like that, right? When read in context, it's clear that that testimony was limited to his behavior on the night of the offense, that he was behaving peacefully on the night that he was killed. Likewise here, if you take harmless out of context, which is what it seems like the court did, that sounds like peacefulness. But when you read it in context, it comes exactly on the heels of this multi-question colloquy about whether, do you think Mr. Mills is kind of a jovial guy? He thinks he's funnier than he actually is, and he likes to crack jokes, and that's kind of his personality. You would say he's harmless. In that context, I think harmless is sort of commonly understood as an idiom for he's a harmless jokester. And that made sense that the defense would be asking that, because
I'm just thinking to myself, if none of the rest of the bad stuff happened, in closing argument, I can just imagine defense counsel using that for all it's worth and arguing to the jury, look, there's one person here in this courtroom who knows my client. One person, and it's Mrs. Robinson. And what did she say about him? She said he's a harmless guy.
well, defense
I
counsel,
want you to go back, ladies and gentlemen, and weigh that and consider that when, I mean, I think that's how defense counsel would use an answer like that.
Defense counsel certainly said in our mistrial motion that that is exactly not what we intended to do with it.
Indeed.
And I think that's clear. I mean, the defense understood what evidence had been excluded. Why on earth would it open the door to that by asking about his character for violence or not?
It was a mistake.
I think it was a misinterpretation, and I think it's critical in terms of what would have come across to the jury that that neither the judge nor the prosecutor, what they said opened the door were these questions about her memory and were questions about her that were very carefully worded about her specific direct observations of whether he had been in possession of a weapon while she knew him during those 2 months and whether he had been in fights while she knew him during those 2 months. This was questioning of a different nature that went to his personality as a jokester. And this court held in Becton that that is not the same as a character for peacefulness.
Okay, Ms.
But-
Terrell, we've kept you way over your time and we will give you some time for rebuttal.
Thank you.
Okay. Ms. Fleming, we'll hear from you. Too many Flemings today. Yes, exactly. All right.
May it please the court, Mary Fleming for the United States. The trial court did not abuse its discretion in permitting testimony about Mills's prior bad acts, that is the prior fight and prior shooting. The evidence was admissible to rebut Mills's character for harmlessness, which the defense elicited. It was also admissible to rehabilitate Robinson's memory. The trial court did not abuse its discretion in weighing the probative value versus the unfair prejudice. And regardless, any error is harmless. So if this court thinks there was error, it should nonetheless affirm. Starting with whether the defense opened the door, on cross-examination, the defense explicitly asked whether she thought Mills was harmless, and Robinson answered yes. That alone opens the door. In context, it was immediately followed by questions about whether she had never seen him fight or never seen him argue with
That's
anyone.
not the question, sorry. Well, I mean, you've never seen him fight, but she's only known him for 2 months.
Right, but I think that in response to the argument that this was only going to his personality as a jokester, when those questions about fighting and arguing immediately follow the harmlessness.
The government
inquiry.
agrees that anything about him being a jokester doesn't open the door.
That's not right. That's not our argument.
Does the government agree that any questions about whether she has seen him with a gun during a limited period of time, that wouldn't open the door either?
I think on its own, that's a much
Right.
harder argument.
So it's the question of, you would say he's harmless, right?
In context with, I think
Right.
these other
And
questions.
the
provide
context is she's
context.
already testified in the grand jury and at trial that he's very kind and respectful. So, I mean, let's say, for the sake of argument, this cracks open the door a little bit. What really the question is what comes in, right? Can we talk about why is it that everything that the government wanted to get in at the outset of the case in its pre-trial motion to get in prior bad acts evidence as evidence of motive is exactly what comes in at trial pursuant to Judge O'Keefe's ruling, and then the government uses it to argue precisely the thing that Judge Epstein said they couldn't use it for?
A couple of things. It came in to rebut the character evidence. It also came in to rebut or to rehabilitate her memory. And
The
the
trial judge backs off of that. I mean,
we
it's a-
disagree with that, Your
it's a
Honor.
I mean, if that's the reason it comes in, I mean, first of all, it seems like there are just so many other ways to rehabilitate her memory than letting in prior bad acts evidence that also doubles as motive evidence and propensity evidence.
So the bad acts evidence goes directly to rebutting the character for harmlessness. The motive piece is not, which would be, as I think appellant's argument is that linking this to the person with dreadlocks. That's not unfairly prejudicial in a Rule 403 context. That's a proper use of the evidence. And in fact, when this was extensively litigated, and I'm not saying that we're not saying that Judge Epstein's order didn't still apply. The government did try to adhere to it.
How did it apply, though? I mean, really practically, how did it apply?
The jury was instructed that they were not.
My question, you got in everything that Judge Epstein had said was not admissible.
And the jury
And
was
then you used it. So I just don't see how it actually applied.
And the jury was instructed that they were only to use that to assess the character evidence about.
And the government got up on rebuttal when the defense doesn't have a chance to speak to the jury again and says, consider this bad act evidence to show that he has a propensity to shoot and that he has a motive in this case to shoot the next door neighbor, which also the government didn't have the goods on whether or not the decedent was the next door neighbor.
I don't think that's right, Your Honor. On rebuttal, we clarified that the dispute the beef is evidence of motive, but the details of the beef can only be used to assess character for harmlessness. And that's on page
Beef is evidence of motive only if the beef was with the decedent.
right. And right.
And that was what was argued in rebuttal.
That well, there was evidence. I mean, I admit it wasn't the strongest evidence, but we had evidence that linking the beef to the person next door with dreadlocks, and the government's theory was that that was Mr. Strong.
Yes, I think the evidence of that, the only evidence I'm aware of at any rate, and maybe I've missed something, but I think the evidence of that was only came out in the government's cross-examination of Mr. Mills himself. When the government, when Mr. Mills, in response to the government's cross-examination, testified that he had a beef with one of the persons who lived in that particular house, and it wasn't the father. And then the government said there was another person who lived in that house, and it was the decedent. And Mr. Mills said yes. Words to that effect. I think I'm saying this from memory a little bit, but
That's correct. There was also evidence from the victim, Mr. Strong's mother and grandmother, I believe, who.
yes, well, there was that too.
And there was the fact that Mr. Strong was next door when this chase started. So that together, I mean, it's circumstantial, but that our theory below was that the beef was with the person.
If the defendant, if Mr. Mills's counsel had objected when the government argued motive and rebuttal, should the judge have sustained that objection?
Not in rebuttal. I think the government's closing confused the issue, and Mr. Mills's counsel. And
Maybe when it was cross-examined, maybe during the cross-examination, an objection would have lied. Although.
Did the government argue that this issue is unpreserved because the defense didn't object during Mr. Mills' cross-examination?
Yes, on page 39 of our brief, we point out that after Mills's testimony, our argument below was that Mills's testimony.
Your brief.
Yes, page 39 of our brief, we point out that Mills testified. We previewed our intent to ask about the prior dispute. Defense counsel said if we have objections, we'll make them at that time. The court agreed. Defense counsel did not object, and they did not object during Mills's testimony.
Can I ask a question? You said that Epstein's ruling, wasn't it Epstein's ruling that the.
So sorry, that's in
go
your
ahead.
harm analysis. That's not a preservation, like you lose because you didn't raise this argument. You're just saying it's not, if this is on page 39 of
Right.
your brief. Right. So that's just saying, well, the harm is minimized because defense counsel didn't think it was so bad. They didn't object. But there are reasons that the defense might not object. That's not a preservation argument, which is what I understand Judge Glickman to be making.
I think our argument here is that this testimony came in through Mills's testimony, and defense counsel didn't object to that. So as
Right.
to whether
But
the
you
door was
have it-
open.
I'm just saying you've only raised that as this lessens any putative harm. You have not raised this as we should review any argument about this for plain error because this wasn't raised by the defense below. You have waived that argument.
Well, the appellant hasn't made that argument
I'm speaking about the line of questioning that Judge Glickman has been pursuing.
I think I might be a little confused. Our argument in our brief is that this is harmless because
Judge Glickman's point is that Mr. Mills is the only one who actually connects the decedent to the beef in which he punched someone and then they shot at him and then he shot back. And the defense didn't object to that testimony. Now, granted, there had been a lot of water under the bridge, a lot of rulings by Judge O'Keefe and Judge Epstein at that point. So there might be a reason that the defense doesn't object at that point. It might seem futile. But nonetheless, one could argue, oh, well, they didn't object, so this is unpreserved, and so we should only review this issue for plain error. But the government has not made that argument. The government has only argued when you are assessing whether or not too much came in the door, you should consider the fact that they didn't object to show that what came through the door wasn't all that harmful. That's the only argument the government has made. Is that correct?
I don't think we can waive an argument that's being made for really the first time argument. I think if this had been raised in the briefs, our response, as we note on page 39, the
Argument in the brief is that the court let in too much evidence to address the misrepresentation or to challenge Ms. Robinson's testimony that she perceived Mr. Mills to be harmless. That's the defense argument.
Correct. Yes.
So I think that argument is before us.
I think to the extent that the court's going to consider Mills's testimony, I would just say I think we've pointed out that defense didn't object to that. It certainly does go to harmlessness. The
government makes a lot of the fact that this dispute was ongoing. What's the factual basis for that assertion?
Ms. Robinson testified that her understanding was that it was
never used that word.
Open-ended since then, I believe, is her testimony. And then Mr. Mills, I believe.
The government actually asks her whether it was ongoing, and she does not agree. She says it was left open-ended. That seems to have a different meaning.
I would read that as,
I mean, if I have an unresolved dispute with someone, that doesn't mean that it's ongoing. It just means that, maybe we never made up. Maybe no one ever apologized. Maybe we avoided each other, as she testified in the grand jury, but it doesn't mean that there's necessarily an ongoing dispute. And yet the trial prosecutor represented multiple times that she had said that it was ongoing. I think that's not a fair reading of her testimony. Do you have any other evidence to show that the dispute was ongoing?
I am. I think that's what we're relying on. We think that's a fair reading of her testimony, that an open-ended.
Just that one Q&A.
I believe so, unless Mr. Mills testified to that as well, and I just can't find it right now, but that's what comes to my mind.
What screening do you think that the court actually did? Right? I mean, if the door was opened, the court has some screening obligation. What screening do you think the court did to consider what evidence should come in? Not why. The court came up with 3 reasons and backed off of 2 of them. But what evidence comes in? Where is that analysis in the court's ruling?
So it's not explicitly in the ruling. the evidence that the government elicited through Ms. Robinson about the dispute was narrower than what her grand jury testimony was. And then when the government started asking her about if
Sorry, you just said that what the government was asking, but I'm asking about the court's ruling.
well, so
You're saying there isn't really anything express, which makes it difficult if we're reviewing for abuse of discretion, right? Because we don't really know why the court thought everything could come in.
Well, when the government started to go into what her reaction to hearing about this dispute was, defense objected and the court sustained that objection. So I do think the court was exercising.
That's not part of its, before she is brought back to the stand, the court makes a ruling that we just discussed when defense counsel was at the podium on the 18th. And the court says, okay, this is what the door is open to now. And it's effectively everything that she said in the grand jury about this beef and about the punching and about the shooting back and forth and about how it was with.
I don't believe that all those details came in during her testimony.
I'm not talking about what actually came in. I'm talking about what the court's ruling was.
Well, I think the court was there moderating what was coming in. I think that,
Shouldn't
and then the
point
court
at which
sustained an
the court
objection.
moderated be when it ruled what could come in? I'm not following. You're saying that the court could kind of say, well, generally everything comes in, but then cut back against that when the witness is on the stand? That doesn't seem like a good way to run the railroad.
I mean, the court's ruling was the question should go to whether the peaceful character, and then otherwise it's more related to the issue of the memory. That's the memory and whatever the government wants to elicit as far as that. I also think that shows the court did not back off on its ruling. This was later in the transcript. So as far as explicitly line by line exactly what the government was allowed to elicit, the court didn't do that, but this was a heavily litigated, carefully considered issue. The standard of review is abuse of discretion.
I'm just not quite sure what I'm supposed to be looking at when I determine how the court exercised its discretion in deciding what evidence came in. And I know I can look on page 13 of the September 18th transcript. Is there any other point of the transcript you think I should look at?
What I just was talking about was page September 18th transcript, pages 47 to 48. At the bottom of 47, the question should go to whether his peaceful character was brought out.
So that's in the midst of her testimony.
This is before her redirect examination.
All right. Anything else you think I should look at?
I'm sorry, just I believe there was a point where the government asked, can we ask these questions? And the court had a ruling. I'm happy to file a 28K letter with that citation. I can't find it right now.
Ms. Fleming, Ms. Fleming, if I may come at this in a different way, and I apologize if I'm missing something obvious. In your view, why was it appropriate for the prosecutor in rebuttal argument to make the motive argument he made?
Right. So Judge Epstein's
about.
ruling, Judge O'Keefe, the parties litigated this before Ms. Robinson testified. The ultimate outcome of that was that the government was allowed to elicit evidence of a dispute as motive, but not the details of the dispute as motive. That was the ruling, and the rebuttal closing, the government was trying to adhere to that line. That, and I think that's right, because the dispute itself is not a prior bad acts evidence, and Judge Epstein agreed with that when Judge
The predicate is that there is sufficient evidence that the dispute was with the decedent, and that would have come from the cross-examination of Mr. Mills.
Well, it came from Ms. Robinson's testimony, well, maybe
She
she
didn't
hadn't
know.
testified.
She didn't profess to know who it was.
She testified on direct that, right, she didn't testify. It came from Mr. Strong's mother and grandmother testimony and the fact that the decedent was found next door.
Did the mother add? I don't remember the mother.
She testified that the father lived next door.
She really didn't have, and actually her testimony was struck. That's why I don't remember the mother.
I think it was a different witness, Your Honor, that was struck. But really the grandmother,
It was the grandmother.
I think it was an eyewitness to the,
Whose testimony was awfully thin.
so the government then put on the grandmother that I think shored up.
The mother's testimony was struck, and then the government put on the grandmother's testimony, and the grandmother could say only that she had visited her son's house once. She didn't say when. And then she said she had picked her grandson, the decedent, up from the house sometimes. She didn't say how many times. She didn't say over what period of time. She didn't say whether she picked him up from inside the house, from outside the house. You know, and this was needed. I thought Judge Epstein made very clear that there needed to be some sort of connection between the decedent and the next door neighbor. And there really wasn't any evidence that even accepting the grandmother's testimony that her grandson, the decedent, was there at the house, that didn't establish that he was the next door neighbor, right? Like,
We agree that he wasn't living there. That's how that's how it came out in the testimony, but he was there, and that was our theory. And the mother's testimony was not struck. It was a
it's
different.
in my neighborhood whose houses I frequent regularly. But I don't know that one could say that that's a basis for someone saying, oh, well, I had a beef with the next door neighbor. It must be Kate Easterly, right?
Well, that's how Mr. Mills described it. He also testified that he would stay in the neighborhood, and he would stay with family or at Miss Robinson's house, or so
What does that have to do with anything?
it's circumstantial evidence
he's
that
not-
he was the person that when Mr. Mills was describing a dispute he had,
He's
that he was
testifying-
describing Mr. Strong.
No, it's not. I mean, he's just saying I stayed when he stayed with Ms. Robinson, he's saying I had a dispute with your next door neighbor. She's not even sure who he's talking about. She never says that she can identify the decedent. She says that there are multiple people next door who have dreads, and she says he could have been talking about, you know, someone 1 or 2 or 3 houses over. So she doesn't provide that information.
Well, that's why the redirect is important, because she does testify on redirect that she knew who Mr. Mills was talking about. She didn't have a
No, she
problem.
didn't say she knew. She said she thought she knew.
The time she thought, and that she had seen him.
She never then said it was the decedent, and the government didn't ask her that question. And of course, it didn't ask her because it knew that she couldn't give the answer. So just that evidence, that connecting evidence that Judge Epstein thought was missing from the beginning, it was always missing. I mean,
We would say that the bar to relevance is a low, this is relevance as far as the dispute. It's a low bar.
bar for relevance is low when you're just talking about, you know, whether or not there was a beef, but when you then use that to get in bad acts evidence and motive evidence and propensity evidence, I would think that the bar needs to be a little bit higher.
Well, I think respectfully that might be conflating two different issues. That evidence came in to rebut the character evidence.
I understand how things came in.
Can I ask, just, sorry, this isn't really switching gears, it's on the same issue, but I just want you to clarify when you say that the government was interested in adhering to Epstein's ruling. I just want to understand what you think of Epstein's ruling as being. Like in the beginning, he says it's too remote, this is unsubstantiated. And is your position that changed at some point because of evidence? And was the evidence different from what was what the government was trying, proffering to Judge Epstein, would support would support the introduction of this evidence?
Not on the probative values,
Yeah.
well, not on the linking the dispute to the person with dreadlocks. What we think changed was the reason it was coming in, and it was no longer just for motive. It was
If it's
also to
still-
reflect character evidence.
If it's still too remote and unsubstantiated, did the government establish the connection? And is the connection not needed to support those other inferences that you think it appropriately was introduced for?
Well, the person with dreadlocks is not the bad acts. The bad acts is the shooting and the prior fight. And so when weighing that, whether that can come in as to rebut character evidence, and then yes, it was linked to the person with dreadlocks, but that was always on the probative value side of the balance, because that's proper evidence. That's not unfairly prejudicial. And there is this ruling that is confusing things. And perhaps the government should have asked to reconsider that when this was coming in. We didn't. We were trying to adhere to the ruling. But
When you say adhere to the ruling, what part of the ruling were you trying to adhere to?
that the details of the dispute could not come in for motive. And I acknowledge we made a mistake during closing. We attempted to fix it during rebuttal, and the jury was ultimately very clearly.
Can you explain that?
So during our initial closing, we elicited the details of the dispute, and we didn't explicitly say motive, but we used it as arguably as substantive evidence. That was a mistake. We cleaned it up in rebuttal, and
Did you clean it up in rebuttal?
we said that the details of the dispute cannot be used as motive. And the jury was instructed that they could only use the detail,
You said that in rebuttal?
the government did.
Yeah.
On page 137, you also heard testimony of what that beef entailed. That specific evidence goes to judging whether Mr. Mills is a peaceful person. The fact that he tells Kyra Robinson that he has a beef with the guy next door with dreads, that goes to motive.
Yeah.
What the government also argued in rebuttal, though, was essentially that what does show motive was the fact that was the evidence that he had this dispute with the decedent, this earlier dispute with the decedent, and that's what is really at the focal point of this. To me, defense counsel should have objected to that because it was contrary to what I understood to be the ruling of the court, the prior ruling of the court. I thought the notion had been that discussion, talk about that prior episode came in on the question of whether he was a peaceful or harmless individual. In other words, came in to impeach the reliability of Miss Robinson's testimony, but it didn't come in under Judge Epstein's ruling, at least, putting aside what Judge O'Keefe said. I'm not sure I understood that. It didn't come in as evidence that Mr. Mills had a motive to attack and kill the decedent. And that's what the government argued. And if there had been an objection, at least, the defense would be in, I think, good shape on appeal.
Well, the dispute was always evidence of motive. That came in through on direct examination. The details of the dispute.
Well, it came, right. And this is what we talked about earlier. It was based on, ultimately, the cross-examination of the government's cross-examination of Mr. Mills, in which through adroit questioning, it created the suggestion that the person he had the dispute with really was the decedent.
I think that's one part of it. There was also other evidence.
There was no objection to that either, if I remember correctly, which maybe there should have been, but.
I know I'm going over time here.
I'm puzzled by your comment that you think that you clarified something in rebuttal rather than exacerbated it. I'm looking at page 137. Do you want to explain to me how that clarifies anything? It seems to tie the two things together. It ties It ties the fact that there's a dispute with the next door neighbor, which you say is motive, with the actual events, which, you know, the punching, the shooting back and forth with the next door neighbor, which you say you clarified was not motive.
That was the ruling, and that's what the government was trying to elicit. And I will say it is conceptually difficult. I agree. The
For a
jury
jury listening to this, yes.
But the
Yes,
jury
indeed.
was instructed, they weren't allowed to use the altercation for any purpose other than to evaluate character evidence. So to the extent these two were tied together, I think the record shows it could have benefited the defense because the jury was instructed to not use
You
the
think
altercation.
when the government says it's uncontested, he told her they did a beef with the guy next door with dreads. And about that, the fact that he tells Kara Robinson that he has a beef with the guy next door with dreads. You also heard other testimony about what that beef entailed. Again, that specific evidence goes to judging whether Mr. Mills is a peaceful person. But the fact that he tells Kara Robinson that he has a beef with the guy next door with dreads, that goes to motive, because lo and behold, what happens in this case? The man who was killed was the man with dreads who was next door. That's who's killed, right? That clarifies everything.
Well,
That benefits the defense.
Well, I think because the instruction was ultimately pretty broad and the jury was instructed not to consider the altercation for any evidence, any
Instruction they
purpose.
got before this argument.
Before and after. Yes, before, during the middle of trial, and then I think the instructions, before closings. The jury was instructed to not
One
consider.
before, during the middle of trial doesn't say anything about motive because the defense asked the judge to say, please let them know they can't use this for motive, and the court refuses.
The instruction said you can't use it for any other purpose.
Yes,
This-
the defense asked for a more specific instruction.
Right, and the court did deny that, but the instruction was pretty broad in that you can't consider it for any other purpose. So to the extent we're trying to use this piece of the dispute for motive and this piece for character evidence, the jury was instructed, I think, especially because Ms. Robinson used the word altercation in describing this dispute, and the instruction uses altercation, the import of the instruction is to not consider any of this for any purpose other than assessing character for peacefulness. But we do agree it is difficult. I know I'm way over time. We do have a harmlessness argument. I'll rest on our briefs on that. If the court has no further questions, we'd ask that the judgment be affirmed.
Thank you very much. Ms. Terrell will give you your 2 minutes on rebuttal.
Your Honor, briefly on the door opening question, this did not come in to rehabilitate memory. I think Judge Easterly, you were correct that the trial judge did back off that rationale. That's on September 18th at pages 20 through 21. The defense confirmed its understanding that it was based on just this one question about harmlessness. That's on September 25th at pages 87 through 88. If there's any question why this came in, you can look to the final limiting instruction where the court explicitly says the reason and the only reason that this testimony can be considered is to test Ms. Robinson's reliability on her testimony that he was harmless. As for the harmless character evidence rationale, we think the ruling that it's character evidence is not a factual finding. This court does not have to defer to it. Even if it were a factual finding, it's clearly erroneous because it ignores the context, and we've laid out the ways how in our brief in which it was asked. And even if it's not erroneous, the trial court still reversibly erred in failing to sanitize the testimony that it allowed through the door as it had previously suggested doing and as the government had previously accepted. The government still has not offered any reason why the connection between those prior acts of violence and the purported decedent was relevant to testing Ms. Mills or Ms. Robinson's reliability. So that alone is reversible error. I want to talk about prejudice and what came in, and hopefully I can clarify the record briefly. So if you'll bear with me, what came in through Ms. Robinson on her redirect? The government asked her, and this is September 18th, starting at page 52, asked after setting out what her testimony had been on cross. But in fact, did Mr. Mills ever tell you he had been in a fight? Yes. Did he tell you when that fight occurred? Not on a specific date. He just made it clear it was at least 3 years prior. And who was Mr. Mills fighting with? Someone that lived near me. And this is the person you talked about with the dreads. The government really wants to make this connection. She says, I believe so, but I'm not 100% sure. The government cares so much about this, it then impeaches her with her grand jury, where she said it was the person who lived or stayed next door in house number 3482 who had long dreadlocks. And then it goes on still and says, did Mr. Mills ever tell you about a time he had a gun? Yes. Did Mr. Mills ever tell you he shot at someone with a gun? Yes. And again, who did he shoot at with the gun? The person who had gotten into the altercation with years before. That's not enough for the government. And is that the person with dreads that you just discussed that lived next door or was next door at 3482? That was my understanding, yes. Now, what came in from Mr. Mills, that right there is reversible. We can stop there. What came in through Mr. Mills is relevant only to harm. The defense would not.
I'm sorry, why is that reversible?
Because at that point, the jury has heard evidence that ties prior serious acts of violence that were similar in nature to the charged crime to Mr. Mills.
You don't buy
and-
my door opening argument.
I'm sorry?
Not my argument. You don't buy the argument that the door was opened by the question of harmlessness.
Even if the door was open on the question of harmlessness, the testimony, A, that there was a shooting over a prior dispute, and B, that that was the same prior dispute against the same person with dreads next door that the government suggested was the decedent, that alone is reversible error because that should not have come through the door. It was, as the trial court said, unbelievably prejudicial and not necessary to rebut any purported testimony from Ms. Robinson that he was a peaceful person who would never commit acts of violence. We know that because the trial court previously suggested addressing that purported misimpression with testimony sanitized to say he had possessed a gun and he had been in a fight, and the prosecution was okay with that. And they have offered no reason on appeal why making that connection between those prior acts of violence and the decedent was relevant or necessary, as this court has said, is required to address any misimpression. So even if the door was open, this should not have come in. And I just want to clarify, because Judge Glickman, I went and did a Control F to find the portion.
I don't know what that means.
I did a search through the electronic PDF to see if I could find the part that you were remembering from Mr. Mills' examination, and I think I found it, which is where the government has a series of questions to him. Specifically, you told Ms. Robinson that the person you had a beef with had dreads, yes, and it started with a fight at the Shipley Market, yes, et cetera. It goes through all the same things that Ms. Robinson has already testified. Critically, Mr. Mills is not saying that those things happened. He's just saying, if she said I told her that, I must have told her that. That's what I said, okay? Also, I think Your Honor was.
He's agreeing that he told her that.
He's agreeing that he told her that, not that it happened. And I think Your Honor was saying that it was only.
He said it makes it a party admission, an admission by a party opponent. It's admissible for its truth.
Well, this was not offered for its truth. The government didn't argue below
I'm
or
saying,
an
it's
appeal
hard
that
to
it
see
was.
that it's not, I mean, well, all right.
That it was
I don't need to get into an
admissible for
argument.
its truth. It was totally uncorroborated too, besides what Mr. Mills is saying to this new romantic interest.
Can I
that
ask
he
you
has.
another question, if I may? At the last minute, government counsel in her argument got around to the question of whether all this was harmless, if ever at all. And I must say, the government's evidence does strike one as pretty strong. All this visual photographic evidence of Mr. Mills stalking and following and chasing the victim, the decedent. And then at the end, shots ring out and the decedent is a dead man. Strikes me as pretty strong evidence that Mr. Mills was alone, was the person who shot him. I wonder if you'd like to speak to whether this really was, harmless error, if ever.
I would. If I may just use 2 sentences to finish my thought on the transcript, which is, I think the part that had stuck out to Your Honor was maybe at the very end of that colloquy with Mr. Mills about what he had told Kira Robinson. The prosecutor goes on, this is 920 at page 182, to say, starts talking about what happened on the night of the shooting and says he encounters Mr. Strong that night. He's on the side of his father's house. Yes, he's outside his father's house. The house is next door to Kira Robinson. That's all Mr. Mills said. He never said anything to suggest that the person he had a dispute with was was the decedent. The person he claimed to have a dispute with was the decedent. In fact, he had said on his, I'm sorry,
He denied that.
on his,
But
he denied
there was
that.
evidence from which a jury could think, it's a brick in the wall. It's not by itself all that much, but it's admissible.
Well, I think the connection came from the government's insistent, repeated questioning of Ms. Robinson about who it was that he had punched and who it was that he had shot at. And that improper evidence that he had previously shot at this person with dreads, and that there's a person with dreads next door who he's being, according to the government, charged with shooting.
I thought it also came from Mr. Mills's testimony that on his cross-examination, that it wasn't the father that he had the dispute with, and there was another person who lived in that house, and it was the decedent.
No, I couldn't find that testimony, Your Honor. He testified that he knew the father, he knew the decedent as Link's son, but that his dispute was not with Link's son. And that he had told her
It was not
about.
with Mr. Link, the father.
Sure, but Ms. Robinson testified there was more than one person next door with dreads. So I don't think his testimony in any way.
There's no testimony that the father had dreads.
There's no testimony that the father had dreads. There's testimony that someone next door, and that there were multiple adult children living with the father next door, and no testimony that that the decedent was living next door, even though according to Ms. Robinson, Mr. Mills said his beef was with someone who lived next door. So I think the harm that is reversible comes in Ms. Robinson's testimony. I think the government's closing argument clearly exacerbated that harm because they used it for this motive purpose. Even when they tried, after the defense corrected them, tried to sort of backtrack off of that in rebuttal, they still said this can be used for his character for peacefulness. That's propensity, right? Is he a violent guy? Which is not what it was admitted for. So I don't think that helped. But the court, even if none of that had happened in closing, this was still extraordinarily prejudicial. And so let me talk very briefly about harmlessness and prejudice. As the prosecutor said, this is conceptually difficult to tease these prior violent acts against the same person for the same motive apart from what little bit of motive evidence was permissible. The difficulty we've been having here talking about it, I think, underscores how very high was the risk that the jury would misuse this evidence. The government's evidence here was strong, but it was not overwhelming. We need look no further than the fact that the jury took 4 days to deliberate and acquitted on the lead murder charge to know that they were not entirely persuaded by the government's argument. The government needed some reason, whether it was first-degree murder or second-degree murder or a compromise verdict. It needed to give the jury some meaty reason why Mr. Mills, after a chance encounter with this person, would decide to kill him. And the fact that they just had a disagreement before wasn't really a very good reason to kill somebody. That's why Judge O'Keefe said it was okay to come in. But the evidence that he had previously punched and shot at this same person over the same dispute, that might be a reason to kill somebody. It filled the keyhole in the government's case. They needed it. They fought for it from the beginning to the end of this trial. They used it for that purpose in their closing because of the trial court's erroneous ruling and allowing this prior crimes evidence in. And so for that reason, we would ask the court to reverse Mr. Mills' convictions and remand for a new trial. Thank you.
Thank you very much. Thank you to both parties for your briefing and your arguments today. And in this case and over the years, Ms. Terrell. The case will be submitted.
I'm sorry, can I just mention to the parties that we do not actually have the government's exhibits? I know council is aware of that. And so we appreciate your efforts to help us obtain them.
Yes.
Yeah, not your fault. And actually just something for both institutional litigants. We're really trying to get exhibits uploaded in Superior Court in real time so that we don't have this issue, and whatever advocacy that you can engage in on your side of the road to make that happen would be greatly appreciated, because the last thing you need to be doing is scrambling for exhibits while you're prepping for oral argument. So thank you.
The second case on this morning's calendar is DARRYL Haywood versus Franklin Johnston Group Management and Development, number 25 CV 291.
Good morning, Your Honors.
Good morning. Can tell council is trying to make it up here. No apology necessary.
We make sure that the door to the courtroom is closed.
Whenever you're ready, council.
Good morning, Your Honors, and may it please the court. This is Neil Satterland of the Neighborhood Legal Services Program of Washington, D.C. appearing
Counsel, I'm
for-
having a hard time hearing you. I don't know if it's possible to lift the podium or speak a little bit louder. Maybe that's as far up as it goes.
Thank you. Neil Satterland of the Neighborhood Legal Services Program of Washington, D.C., counsel for defendant appellant DARRYL Haywood. I'd like to reserve 3 minutes for rebuttal.
Sure.
The trial court's decision must be reversed because it depends on one finding of fact, which was a clear error based on the trial court's misunderstanding of the record. I will walk through that error, lay out how the landlord's pre-suit notice necessarily limits the judgment to that one question of fact, and discuss, time permitting, the trial court's confusion as to what type of case this was and the resulting unfairness of the trial. The trial court told us how it arrived at the dispositive finding of fact that Mr. Haywood wrote the anonymous threatening letter. The trial court told us it was a comparison between eyewitness testimony and the record of this case, which the trial court says was the thing that, quote, certainly tipped the scales and convinced the trial court, quote, with regards to the author of the letter being Mr. Haywood. This is all on page 185 of the appendix. The trial court manifestly thought that there had been only one property manager, plaintiff's chief witness, LaToya Anderson. In fact, as LaToya Anderson testified on page 98 of the appendix, she was the assistant property manager. Her predecessor, at times also relevant to this case, she says this on page 115, was Shaniqua Law. So, quote, the court note.
I think we understand your argument, and we read it in your brief, that the court seems to have ascribed this name confusion to Mr. Haywood that is neither present in the letter nor present in his testimony. And you relied on that to say you must be the author of this undated, unsigned, really unauthenticated letter. So if we agree with you about that, then what?
Then I think there is no evidence in the record on which to sustain the decision that he wrote the letter.
Right, but I mean, what's so confusing about this case, right, is that so the notice and the complaint say that they're bringing this case under 42-3505-01C, which is wrong.
Yes.
Because that requires a prior adjudication of criminal activity, and there's been no prior adjudication, certainly not at the time of the notice and not at the time of the complaint. That's what the trial in this case was for, right? So then we're under 01B, right? And the argument is that our decision in Scarborough applies such that it's, you know, he doesn't have an opportunity to cure for a criminal act. But if we consider this as a 01B case, it does seem like the landlord is trying at trial, not so much in its complaint, is trying at trial to turn this into just a garden variety lease violation case of, you know, he engaged in this kind of obstreperous, harassing behavior, you know, not necessarily criminal. So what do we do with that evidence?
I think all the evidence.
Do you agree, first of all, I guess, do you agree that the court ruled that he could be evicted on that basis?
Yes, I think the court seems to have been itself confused, as Your Honor points out, as to what type of case this was. I think the court could only properly have ruled that he could be evicted on proof by a preponderance of the evidence that Mr. Haywood had committed a criminal act in the property threatening the safety of.
Do you say that because it's a 01C case, or you say that because that's the only evidence that would have supported eviction at trial?
Because, Your Honor, the pre-suit notice that Mr. Haywood was served did not give him an opportunity to cure. They were just the only thing that allows a landlord to do that, to skip notice and a 30-day opportunity to cure and just say, we're going, you know, for judgment, even if you never do it again, is a crime.
So is that, how does it work when, if the lawsuit is an action under C, all the parties seem to think it's about B, and you were saying, what were you just saying about how that evidence does not comply with say again what you just said? I'm sorry, that triggered my question.
So the notice, which
Oh, right, the notice. How do we
Two
decide? Because he
seconds.
doesn't get notice under C, right?
Right.
And then he does get notice under B, and the trial judge erroneously thought that he had been given notice as well as an opportunity to cure.
But the notice does say C, which, as Your Honor pointed out, I think is probably wrong.
Right, but how do we decide, you know, if it's a case, you know, that has two kinds of claims, and one, you know, it's clear that notice is required, and one, it's clear from case law or whatever that it isn't. Do you get notice? You have to get, is it a claim by claim issue? It's very confusing here because the lease violation claims seem to kind of be used in support of the letter claim. And that sort of seems like a freestanding kind of claim, even though it is also treated as a lease violation claim. I don't know, it's very confusing, but.
It's a friendly amendment to Judge.
Or answer,
Beckwith.
yes.
No, I'm not answering the question.
Okay.
Can we talk about the 01C claims, which I take it we're agreement that this is not, because that requires a prior adjudication of criminal activity. So put the 01C claims to the side. And then there's an 01B type claim And let's bifurcate that, right? There are Scarborough claims and non-Scarborough claims. So Scarborough claims could be claims of criminal activity for which you would not be entitled notice that you would otherwise be entitled to under B, but for our decision in Scarborough that says that it's preempted by federal regulations that I think we said in another case have to be incorporated into the lease. They're not self-executing. So this lease has to actually incorporate these CFR provisions. So there are Scarborough claims, and then there are non-Scarborough claims, which are not criminal and would require notice.
Yes.
And so here we seem to have a case where there was notice under C1, which was wrong, that referenced a threatening letter that could be a Scarborough claim under B, that didn't say anything about the harassing behavior that could be a non-Scarborough claim under B. Then we have a complaint that again references the threatening letter, but cites to C and the CFR provisions, and then says I can't remember, did it say that there was no notice to cure, or that there had been a notice to cure and it hadn't been cured because of this continuing?
Complaint incorrectly believes that there was a notice to cure.
Right, which was wrong.
Right.
If all we're talking about is the non-Scarborough, if all we're talking about is the Scarborough claims.
Which has to be all.
We're talking about the Scarborough claims, there should have been a notice to cure, but there never was one.
Right. And so I think that none of the non-Scarborough matters were properly before the court at all. And I think that the transcript contains maybe 1.5 pages of relevant testimony.
Well, there is the issue of a lack of objection to any of that, or, are you saying that doesn't matter?
Well, I think Mr. Haywood, appearing pro se, was repeatedly admonished by the trial court that this was a case that was about something other than what this case was supposed to be about. And I think Mr. Haywood firmly denied writing the letter. And
He did agree that it was a lease conditions case. I mean, I understand you're saying he's pro se, he might not have known what he said, but he did say that.
I don't think that he can, waive notice. I don't think that he has the legal capacity to say that it doesn't matter that he's being tried on things that he had no notice of prior to the day of the trial.
Do you have a case for that?
There's Grimes v. Newsom, 780 A. 2nd 1119, in which this court said that the notice must contain sufficient detail to enable the tenant to understand what conduct violates the lease and what corrective action is necessary.
But for your proposition that notice can't be waived.
Well, I think
you raised it before I believe you were counsel when review was sought to the associate judge, and it was raised at that point, as soon as he had counsel.
Yes. And I think, if we are expanding beyond the scope of the notice, I think that we are running afoul of 14 DCMR 4301.4, which says the tenant has to be told what the violation is in sufficient detail to allow a reasonable person to, in the circumstances, to know what allegedly occurred, and the specific actions the tenant needs to take to correct the violation in sufficient detail to allow a reasonable person in the circumstances to know how to comply with the directive. If he hasn't been given an opportunity to cure anything that is not a Scarborough matter, then I don't think he can properly be evicted.
I'm inclined to agree with you that the only question here is whether what we've called the Scarborough claim can be upheld or not. And I think that two questions seem to come to the fore. The first question is whether this whole proceeding was fair because Mr. Haywood was not provided with the letter until it was shown, I guess, at the hearing. And he did complain about that. The second question is whether the trial court committed clear error in finding that Mr. Haywood wrote the letter. The evidence of that was, I think anyone would agree, thin, if assuming it's existent, but thin in any event. And so it seems to me that those are the two questions on which this appeal turns.
I agree
If you
entirely.
could speak to those.
So as to whether it was clear error to find that he wrote the letter, we have the trial court's articulation of how it reached that conclusion. And I think the worst case scenario for Mr. Haywood would be that this is precisely what came up 2 years ago in Sanchez v. Sunderland, where this court said, if the fact finder sets forth the reasons for its decision, and it reached that decision based on clearly erroneous interpretations of the evidence that prejudiced the losing party, even if the fact finder could have permissibly reached the same conclusion for reasons other than the ones that it gave, that cannot be a basis to affirm the decision.
You're right about that. What is the remedy? I mean, do you think that there is this something we should send back to have the judge, say this was error, try again? Or do you think there's, insufficient evidence of, no matter what, as a matter of law, to support the conclusion that Mr. Haywood was the author of this letter? What do we do if we agree with you?
Think my starting position is certainly that there is nothing in the record that could be a basis for concluding that Mr. Haywood wrote the letter. So I think the matter should simply be reversed.
Is that what you asked for in your brief?
We asked for a reversal or in the alternative for a remand for proceedings consistent with this decision was reached incorrectly. I think in that case, there would more or less need to be a new trial to determine whether there was any evidence that Mr. Haywood did write the letter, because the only thing
That's why I was asking. My impression, but I don't have what I was thinking of before me, was that you were asking for a new trial in your brief, but Judge Beckwith's question suggests that maybe a new trial would not even be required. There could just be a flat out reversal because the evidence is legally insufficient.
yes, I think we're
Did you make that argument? Or?
we're presenting that in the alternative. I think we ask at the end of our reply that the court should reverse the trial court's judgment or at least remand for a new trial.
I mean, if the evidence was insufficient, then that's the end of the matter.
Yes.
If there was some procedural problem, maybe not, but.
Yes, Sanchez sets up a two-tier system three tiers. Either there's no evidence on the record on which the decision could have been made, in which case reversal is appropriate, or in the alternative, if this court finds some way to cobble together some part of this record into potentially evidence of authorship of the letter, then that would necessitate.
It's really a question of whether your adversary finds some way to cobble the evidence, but.
So yes, I think, the most appropriate course of action would be simply to reverse for.
What about Judge Mattini seems to be saying, I think, that yes, this might be a problem with one of the facts found in support of Mr. Haywood's authorship of this, but that the judge had heard all these witnesses and really was making a credibility finding. And you know, it's true, Mr. Haywood testified, you know, he's representing himself. So basically he just talked for a very long time about everything that happened in his life. And you know, heard the testimony of the other witnesses. And, you know, why doesn't Mattini have a point that, yeah, there might have been an error in the way the judge perceived a small part of his testimony and its comparison to the letter itself. But we can glean from the record that she was making a credibility finding that was supported.
Well, we might have had to glean that as the basis for her decision if she had not spelled out in such detail what the actual basis for the decision was. I think that the Honorable Judge Mattini just also hallucinated a credibility determination that was not there, or that was not connected in any way to the one finding of fact. The only things on which the trial court relies on eyewitness credibility are non-Scarborough claims, where she finds that the plaintiff's witnesses testified credibly, and Mr. Haywood was you know, not his own best friend in trying to oppose all the credibility.
Is any of that testimony, which is you may arguably supported by credibility, do any of those incidents, you know, interactions, I guess, arise to, you know, are they serious enough to support a lease violation?
Well, I don't think that frankly matters, because a lease violation, he would have to have been given an opportunity to cure before he could be properly evicted for having continued to do non-criminal lease violations.
But humoring me, do you think, even given that, do you think they do?
Well, I think that is, you know, a decision to be made after a different type of case has been brought. I think that, you know, there's no way to evict someone based on a finding that they're just kind of a pain. And he's only properly being tried for the thing that he's been given notice of.
Going back to something you said about Judge Mattini, we are technically reviewing her ruling, right? Not the ruling of the magistrate judge.
Yes, but
And so Judge Mattini gives kind of two reasons. I thought this is what you were referring to for why one could believe that your client is the author of the letter. The one is that there's maybe this mix. Well, I can't remember if she actually mentions the mix up about the names, but she talks about how the Ms. Anderson testified that the threats towards the residents in unit MO3 were written in the letter were noteworthy because defendant had a prior altercation with residents in that unit. But does the letter, this is where I keep getting the numbers confused. The letter mentions MO3, but Ms. Anderson doesn't testify about a prior altercation with tenants in MO3. She testifies about an altercation with tenants in a different unit.
M13.
M13.
Yes, that's on pages 102 and 103 of the appendix, where, you know, that's the only testimony that the plaintiff presents on its theory of why it can be determined that he wrote the letter. And I think it is, as one of your honors pointed out, a pretty weak evidence, given that the point that they land on is that there were things in the letter that were known only to Mr. Haywood and a few others. That's on page 103. So I think that's not what the trial court used as the basis for its decision. And we have.
And it's just wrong for Judge Mattini to say Ms. Anderson connected the letter to Mr. Haywood because he had had a prior dispute with the tenants in one unit. I've lost where I started the sentence. Anyway, Ms. Anderson testified that she connected the letter to Mr. Haywood because he had had a dispute with tenants in one unit, but the letter actually references tenants in a different unit. So it's hard to understand how that would be a reliable basis for Ms. Anderson to think that he wrote the letter, much less a reliable basis for the court to believe that he wrote the letter.
I think that that's right. And I think, you know, even if there is any other reason for thinking that he may have written the letter, we have on Sanchez v. Sundali on page 541, we cannot be confident that had the court's decision not been influenced by its erroneous findings, it would have reached the same conclusion. So I think at the very least, the fact that the trial court told us what tipped the scales on that fact finding, and that was a clear error. I think it cannot be affirmed.
Thank you. We will give you a couple minutes on rebuttal still.
Thank you, Your Honors.
Good morning, Your Honors. May it please this court, Gregory Dumont for Franklin Johnston Group. It was not reversible error for Judge Mattini to look at the record below and come to another subtle different conclusion than the one reached by Judge Boucher, the magistrate judge who tried the case below. As this court has pointed out, Mr. Haywood was more interested in telling his stories and had to be repeatedly brought back to what the case was about, according to the court.
Did the court tell him the case was about?
Case was about the letter and was also the interactions between his interactions with the property management and staff.
Why was it about the interactions with the property management if that wasn't part of the notice that he received? And it really wasn't the focus of the complaint other than as part of saying that he had failed to cure, which he didn't have a right to cure for Scarborough claims.
Correct, but that was that was in the complaint and he was on notice that his interactions would be.
But if that's the basis for the if the basis for the eviction is the Scarborough claim, the 01B claim, why does his other harassment matter? Why is it relevant? Right? It's the only question is, did he write this letter, which is, you know, could be construed as a threat, which is a criminal act, which if the landlord's lease incorporates the CFR provisions that say that landlords can evict people for criminal acts, would allow the landlord in this case to evict him. Why do we have to think about any of that other stuff that he didn't get notice for? Right, like the landlord decided what this case was going to be about. They gave him notice and they said, I mean, incorrectly, that it was an 01C case. That's wrong, because he hadn't been previously adjudicated a crime, but it said, you know, the letter is what we're going to go on. I guess I have another question, which is, if this is a Scarborough case, we said in Scarborough that the way this works is that generally 01B cases, you have a right to cure, right? A right to notice. To get notice for an opportunity to cure. But that's only if the property is federally subsidized and if the lease has incorporated the CFR provisions. Is there any evidence in the record that this property is federally subsidized?
I believe it is federally subsidized and this is
Is there any evidence in the record of that? I saw in the complaint that there's a box checked that it says that it's subsidized. But the question is the property subsidized by the federal or local government? And the answer is yes. And beyond that, I didn't see any, and there was no evidence presented at trial that this is actually a federally subsidized property. And if it's not a federally subsidized property, then Scarborough doesn't apply. Scarborough only applies to federally subsidized properties. So I'm just curious, why can we even proceed under Scarborough if we don't know if this is a federally subsidized property?
As to that, I believe it was adjudicated that Mr. Haywood does receive a subsidy in his tenancy. He spoke of
But what's the nature of that, right? If it's a local subsidy, Scarborough doesn't apply, right? The local notice rules would apply. If it's only, right, the rationale of the Scarborough decision is under the DC code, tenants have the right to notice except in limited circumstances under C, if they've been previously adjudicated a crime, or under B, if they've been, if they are in the eviction proceedings adjudicated to have been involved in a crime in a property that is federally subsidized because the federal regulations preempt the local law. But if we don't know that this property is federally subsidized, then we don't know that the federal regulations preempt the local law. So I didn't see any.
I'm afraid I don't recall anything in the record that would say, that would
Yeah, I
make
don't
that
think
explicit.
it's there. I don't think it's there.
Has your opponent raised the question of whether this property was federally subsidized?
Don't recall that in the pleadings, no.
So assume that Scarborough applies.
It's been the assumption all along.
Right. Then why shouldn't we reverse if the trial judge mistakenly thought that but that both the author of the letter and Mr. Haywood had made a mistake about names that then the court thought it could connect Mr. Haywood to the letter, when neither the letter nor Mr. Haywood made the mistake that the magistrate judge thought he had made, or the author had made.
The author of the letter never identified Ms. Anderson's last name. Mr. Haywood had stated all along he never knew her last name. He always thought her last name was Law. So it may
But
be.
that's not what the magistrate judge thought, that because someone was taught that because Mr. Haywood was talking about a Ms. Shaw.
Correct.
Right? But nobody talks about a Ms. Shaw, neither Mr. Haywood nor the author of the letter. So this connection that the court is drawing to say, aha, he must be the author of the letter because both he and the author of the letter are misidentifying a property manager as Ms. Shaw. Nobody does that. It's like a made up reason. So if it's a made up reason, why shouldn't we just reverse this?
Again, according to Sanchez, it would be more appropriate to remand for further findings with to flesh out further what may have been incorrect. However, in this instance,
I'm sorry, can you explain what, I don't understand what that means. Flesh out what, we know that it's incorrect. It's on the face of the record that that's incorrect.
there are other facts in the record, however, that
The court didn't rely on, so I think we can assume that the court didn't find them persuasive. I mean,
the court doesn't say that it didn't find them persuasive.
court says,
If-
this is what's making me help make my decision. My decision is being made because I think people made this name mistake. And it doesn't rely on the reasons that the landlord gives to the court. It says, this is why. The implication is it didn't find the other reasons terribly persuasive, and it thought that its made up reason was the most persuasive one. And it would have been a good one had it been actually factually based, but it, unfortunately, it didn't have any basis in the fact at all.
If I may, setting aside the reasoning of the court below, can you point to evidence in the record that supports a finding that Mr. Haywood wrote the letter?
Mr. Haywood had spoken about he had been arrested for the letter, and that he had, I think he used the term parole, but I think it was probation because of an assault with Mr. Chapman.
Mr. Chapman isn't mentioned in the letter.
Not in the letter, no.
No, and
Well-
why does the fact that Mr. Haywood gets arrested after the letter is discovered? And by the way, like the authentication of the letter, like there's no evidence in the record as to how the letter gets to anyone. I mean, we have no idea. Supposedly it's sent to corporate. I have no idea where corporate is. I don't know whether, it seems Ms. Anderson and Ms. Law, when she worked for the landlord, worked at a different location. We have no information as to how the letter was transmitted to her, how she became aware of the letter, when the letter was received, the letter's undated, the letter's unsigned. What else do we know that would make us think, I mean, yes, Mr. Haywood seems to be a problem tenant, but what else? Are difficult?
Only the facts alluded to in the letter that with the altercation or
Yeah, but it
interaction
mentioned,
with
it
the other
mentions
tenants.
the
And
wrong
then,
unit.
I'm sorry,
Ms. Anderson said, well, I thought he was the author of the letter because he had a fight with the people in unit 13.
yes.
The letter doesn't mention a fight with people in unit 13. The letter mentions
Mentioned
a
them
fight
three.
with the people in unit 3.
I think that probably was a mistake as to confusion between
Mistake
13
by
and
who?
3
By the author of the letter or by Ms. Anderson?
by Ms. Anderson.
Well,
She was
but-
there when
But
she
she's not. I
she
mean,
stated
did the
that
landlord cross-examine? Did the landlord try to correct her? I mean, her testimony is he had a fight with the people in unit 13.
in front of her.
Yes. And I don't know why that makes this letter more or less likely a product of Mr. Haywood's brain. It mentions a fight with people in unit 3.
Perhaps Mr. Haywood confused the apartment numbers.
I mean, that seems speculative. Did you ask him? I mean,
I did not cross-examine him. By that point, we had
you did not.
we had gone for quite a while
Yeah.
on his testimony.
Can I ask you to clarify something? In defending the judgment of possession, are you relying on any alleged lease violation that was not specified in the notice to vacate?
None that had been given notice other than what was in the complaint. We alluded to the fact that there was ongoing problems in his subsequent interactions. But
So
that was the
if you're
extent of
talking
the
about the
notice.
complaint, like in the notice, you talk about the threatening letter. And that's it. So you're saying other than what's referenced in the complaint, and the complaint says the defendant's conduct talks about the defendant has violated the terms of their lease in the following way. He sent a letter to the landlord. This conduct is a criminal threat of violence. So that's what you're relying on?
And further below that, the conduct has continued.
Yeah, but that's under whether or not he has failed to cure his violation.
Correct.
So that's not a separate basis for eviction. That just goes to whether or not he cured, which he wouldn't have had
He
the
wouldn't have
right
had
to
to under
cure
Scarborough.
under Scarborough, so it seems irrelevant.
Understood. There are no
So it's
further.
fair to say you're relying on the letter.
Yes, Your Honor.
Okay. Thank you. Anything else?
If it pleases the court, I have nothing further.
Thank you very much. Mr.
Mr. Saddleton, may I ask you a question? Let's assume that the facts are as follows. The letter refers to a fight that the author had with somebody in an apartment in the basement. And the witness comes in and says, indeed, Mr. Haywood had a fight in an apartment with someone in an apartment in the basement. And let's assume further that one can fairly draw the inference that they're both talking about the same apartment, even though the letter gives one number and the witness gave a somewhat different number. Let's assume that's the only evidence that there is that bears, if at all, on whether Mr. Haywood wrote that letter. Would you address whether that by itself, again, assuming they're talking about the same apartment, whether that itself is sufficient to establish by preponderance of the evidence that Mr. Haywood wrote the letter?
I don't think that it does give reliable evidence of that. I don't think that shows by a preponderance of the evidence that it must have been Mr. Haywood who wrote the letter, because I think the tenant of whichever apartment it is, if indeed we speculate that they are the same tenant, would have
Voted to get rid of Mr. Haywood.
exactly. And I think that the structure of the letter is pretty telling, because in the midst of this litany of threats of expensive violence and vandalism and visiting death on the corporate office, which Mr. Haywood never had any interactions with that appear in the record, the boast in the letter is, I don't even care if I get evicted, which sounds like the thing that you're focusing on if your thought is, can Mr. Haywood be evicted? Rather than what you're focusing on if you are announcing that you will bear whatever consequence may come of your planned rampage. So I think it reads very much as the letter that you would write if you wanted to convince the corporate office that it needed to take aggressive action to try and remove Mr. Haywood, to give them their own self-interest to consider. So I think
maybe there's I assume we're all in agreement that the letter constituted a threat of violence and would be a criminal act that would trigger eviction in Scarborough if he wrote it.
If the determination were made that it would cause a reasonable person to think that this was true,
right?
I think it's at least debatably a criminal threat of violence, and I think the stronger argument is the trial court told us why it thought he wrote the letter, and it was just the trial court's own hallucination of the record. To a point that was raised earlier about what the judge told Mr. Haywood the case was about, at least two instances live on.
Let me just, if I could just, the reason I put it the way I did is because I think the sufficiency of the evidence goes to whether we simply reverse or whether, if it is sufficient, we remand for further proceedings. That's where I was going.
Right. And as I've said, I don't think that is, given the failure of anybody conducting this trial to develop any more of a record than we have. I think that record doesn't have anything on which one could conclude by a preponderance of the evidence that Mr. Haywood wrote the letter. Both because of the misidentification of the apartment at issue and the fact that the plaintiff's evidence that it presented for that proposition was the letter says things that would be known only to Mr. Haywood and a few others being people that Mr. Haywood has had a strong disagreement with and have a motivation to try and act against him. So no, I don't think the record does have a preponderance of evidence that would support Mr. Haywood writing the letter.
we were to agree with that, is it still necessary to deal with the other alleged lease violations, or is your position just there was no notice, so no?
Yes, Your Honor.
Um, and was that argument, we got back into the you can't waive your notice, right? But was that argument made to Judge Mattini?
That only the notice was properly before the court. Yes, that is in the 80s in the appendix, I believe. Oh no, the 80s is Judge Mattini's order. On page 69 of the appendix, we do go into the trial court having erred by permitting this irrelevant digression into things that were not subject of any notice.
Is it established in the record that he didn't get notice? I mean, is that just?
Well, the notice was attached to the complaint, and a copy of it appears on page 62 of the appendix. That was the notice that came with the complaint, and if the plaintiff thought that there was any other notice that should have come up, I would think the plaintiff would have to say so, which it does not.
Anything else, Mr. Satterwhite?
Unless your honors have any further questions, we ask for the trial court's decision and the denial of review of that decision to be reversed.
Thank you very much.
Thank you, your honors.
Thank you.
Thank you.
The case will be submitted. And I'll call it the third and final case of this morning's regular calendar. Is number 24 CM 1025, James MCRAE versus United States. Whenever you're ready.
Good morning, Your Honors, and may it please the court. Ashley Carter on behalf of James MCRAE. Your Honors, I'd like to reserve 2 minutes for rebuttal. In his initial briefing, Mr. MCRAE asked the court to reverse his conviction for simple assault for 5 separate reasons. Today, I plan to focus my time on the self-defense issue, but if the court has any additional questions about the remaining issues, I'm happy to answer them. This court should vacate Mr. MCRAE's conviction for simple assault because the government failed to disprove beyond a reasonable doubt that he acted in self-defense. Once self-defense is raised and the defendant provides evidence to support it, then it is the government's burden to disprove the elements beyond a reasonable doubt. The elements are first, that the defendant had an actual and reasonable belief he was in danger of imminent bodily harm, and second, that the defendant used reasonable force in response. To meet this threshold, the case law says that a fact finder must be able to conclude with a subjective state of near certitude that the appellant did not act in self-defense. That is from Williams versus United States. This is a high bar, and the government's evidence did not meet it. First, no reasonable finder of fact could have found the government disproved Mr. MCRAE's actual and reasonable belief that he was in imminent danger of bodily harm. I think the facts of this case are very specific to this case, Your Honor. There's not a lot of cases that looks like this. So I think it is really important to be grounded in the record of what happened here. So we do know that Mr. MCRAE reacted to one of the complainants, MH, calling him a name, and indicated that he was coming back and then ran towards them. The government's brief calls that a charge. I think that's a misreading of the record here, both of what the witnesses actually testify to and what the judge finds. So if you look at what's actually in the record, the judge's finding, which is on 110, page 110 of the transcript, is that Mr. MCRAE was running back up on them from the back. I think that what AC testifies to is that Mr. MCRAE ran and made a beeline for MH, and that's on page 38 of the transcript. I think the government's brief is misreading something else from page 110, which is the judge stating, quote, that AC was trying to take the charge, you'd say, on a basketball court. I read that to be a basketball euphemism. I don't think that is the judge finding as a fact that Mr. MCRAE is charging. I think that the evidence does not support that, and I think that that's not what the judge was saying. So I think to say it's a charge is not correct. I think what Mr. MCRAE was doing was running at the individuals. AC testified Mr.
Running
MCRAE
as opposed to charging?
as opposed to charging.
And what's the difference?
I actually checked Merriam-Webster this morning, Your Honor. The definition of charge indicates an attack, indicates violence. I don't think there was any violence indicated here. I think the only thing that's indicated is Mr. MCRAE is running towards MH. Charge implies some
Right,
kind of
but then, I
violence.
mean, the sort of undisputed fact seems to be that Mr. MCRAE is re-engaging. If we could use a neutral term, right? Like, if my understanding of the facts are they are walking along, he runs by them, you know, words are said that he finds insulting. He says, I'll come back, and runs back towards them. I think, as the judge said, what you just read, from behind, and he's running towards them and is re-engaging them and seems to be going straight for MH, who seems to have been his target on previous occasions. So then I can't remember, her partner steps in between Mr. MCRAE and MH, right?
That's correct, Your Honor. I would say that re-engaging is a good term for what's happening here, but this is all verbal at this point. I think
Right,
Mr. MCRAE
but
is running.
why if someone is running towards your partner and you step in to sort of shield, why is that something that then gives the runner reasonable fear of bodily harm? They
Yes.
seem to be the instigator.
So, Your Honor, I think calling him the instigator, I think is not exactly an appropriate term for what he was doing. I think he's certainly re-engaging them verbally. He says.
He's the
"I'm hitting
re-engager.
them."
We'll call him the re-engager.
A re-engager, certainly. I think that what is really important here is that there is no indication that anyone is going to engage in any form of violence at all until AC steps in front of Mr. MCRAE and they collide. This is happening very quickly. I think MH's testimony is it happens in a minute. That's her best estimation. The entirety of the interaction from when he passes them to when he leaves the scene. And so all of this is happening very quickly. Mr. MCRAE is running and AC gets in front of him and collides with him. And I think there is no.
But if he hadn't stepped in to shield his partner who is behind him, Mr. MCRAE would have collided with her from the back.
I don't think we know that, Your Honor. I don't think there's any evidence to suggest that he intended to collide with her. I think that we know he was coming back.
The question is whether it's a fair inference for the trier of fact to draw.
I think that's true, Your Honor. I think the judge in this particular case, I think there's a struggle here with the fact that he doesn't mention this collision at all. And so when he's doing his analysis, he mentions that AC gets in front of Mr. MCRAE. He doesn't mention the fact that they collide. And I think that's a really important fact. I think the fact that they have made physical contact at that point means that there is a reasonable belief for Mr. MCRAE that at that point he is in danger. It's not until that collision happens that he's in danger.
Right, as an accidental collision, which it seems that's what you're portraying this as, are you ascribing to the person who steps in between some aggressive motive to hurt Mr. MCRAE? I'm not sure why would an accidental collision give someone a reasonable belief that they're in danger of bodily harm and give them the basis to lash out, punch someone else?
I would dispute that it's accidental, Your Honor. I don't think that anyone goes out there with the intention to harm each other, but I do think AC intentionally gets in Mr. McRae's way, intending to stop him. I think that's his purpose. I don't think that it's an accidental collision.
I'll accept that. Why does that give him a reasonable belief that he is in danger of bodily harm?
Your Honor, the case law says that it's all about his perception of what's happening. It's not about what AC intends to do. So maybe AC is acting perfectly reasonably here. I don't dispute
It's not
that.
all about his subject. It's reasonable.
It's whether his subjective belief is reasonable. Yes, Your Honor. But I think that what Mr. McRae is
Why is
perceiving.
it reasonable for him to have the subjective belief that if someone steps in his way such that they collide, that he is then in danger of additional bodily harm that justifies him punching someone?
I think it is the entirety of the circumstances, Your Honor. I think it's the fact that Mr. McRae, I mean, because it's happening so quickly, for one thing, because Mr. McRae doesn't really have time when this is happening to step back and say, I need to reasonably appreciate what's happening. Case law says we can consider the heat of the conflict. It says we can consider the
There's no conflict yet. That's my question, is where does the conflict come from? I mean, he's the one who's running up onto the scene and re-engaging, as we've discussed. So where's the conflict? There's an accident, there's a collision for some reason. And I'm not seeing where the danger, the reasonable perception of bodily harm is coming from.
I think what the case law says about the heat of the conflict, Your Honor, is that it's about Mr. McRae's particular
That's
circumstance.
if there is a conflict.
Well, I think there is
And if
definitely.
you look at those cases, and as you say, those cases aren't super helpful in this circumstance because this case doesn't look like any other case. And maybe this case doesn't look like any other case because other cases, there's perhaps more to support a self-defense theory. But in other cases, there's an actual pre-existing conflict. And here, I mean, beyond, words exchanged, which you agree are just words, there's no conflict. Words have been spoken, they walk on, he runs that way, he re-engages. There's a collision. I'm still not understanding why he thinks he can use force.
I think at the exact moment that he is coming back, Your Honor, he is not perceiving that he's going to hit anybody. I don't think that's his intention in going back. I don't think there's evidence of what his intention was in going back except his testimony, which I acknowledge the court discredits. So, but I don't think the government puts on any evidence about what his intent is in terms of harming them. I think he's running back towards them. That's what he's intending to do. That's what the evidence.
Why is he running back toward them?
I think the evidence does show he wants to confront them verbally. I mean, that's what the government seems to be presenting.
Why do you say the evidence shows he wants to confront them verbally?
I think he says, I'm coming back, and it's
Right.
in response to the fact that the person.
That he's just been called a name?
Yes.
And, well, let me ask you, I guess I have a couple questions for you. First of all, you assume, your argument here assumes that, what are his initials, AC? I forget, whatever.
The complaining witness,
Doesn't
yes, Your
matter.
Honor.
Actually steps in front of him to shield the one of the women. My recollection from the briefs is that that may not be what happened. There was evidence that actually he just moved to the side, and that in effect, Mr. McCrae maybe shifted his focus and instead of going toward the woman who had insulted him, ran toward her male friend. Am I right about that? That there was evidence of that the collision occurred not when not when the male was in front, was in between McCrae and the woman?
So I think you're correct that there is sort of a discrepancy between what the witnesses say about what happened. So we have MH's testimony and AC's testimony, which differs as to where.
So could the judge have credited the scenario that I've just described?
I think that AC says he steps to the side, but that it is to get into Mr. McRae's
But-
way. So it's to get between MH and Mr. McRae. that is his purpose. So even if he steps to the side, he's doing it to get in the way. What the judge ends up finding is that
But if he wasn't
got in
in the
front of
way, then you're, in fact, at the time of the collision, then your argument collapses, right?
I think it would if that had not been the testimony.
Now, let's put that aside. The other question I wanted to ask you is, tell me what you think the evidence shows exactly, step by step or inch by inch, after the man stepped, I'm sorry, I keep forgetting his name. After he steps in the way.
Right, so AC steps in the way and says that they collide chest to chest. That's his testimony.
Okay.
And then I think that he testifies immediately that that's when Mr. MCRAE begins to hit him.
And he
that-
has wounds that indicate that, right?
He has injuries, yes, Your Honor.
Where are the injuries located?
On his neck, on the sides of the neck. So we did supplement the record with the photographs, Your Honor, if Your Honor would like to take a look at those.
And those injuries are presumably inflicted by Mr. McRae's fingernails, or
Seems to be the testimony, Your Honor, is that there
Okay.
were scratch.
is he bruised as well around his neck?
I don't think that there is bruising. I think there may be some redness on his neck.
Was there any injury whatsoever to Mr. McRae?
No testimony about injuries to Mr. McRae.
Okay. So even assuming that the collision itself was in some sense, what you're arguing is accidental on the part of Mr. McRae, where does that get you if Mr. McRae then injures the person he collided with neck by scratching it or whatever?
So I do think that goes to reasonable force, Your Honor, and whether or not he used reasonable force in response to the threat that he perceived.
How is that force reasonable?
I think that is, the case law says that the secondary responsive aggression has to be completely disproportionate to the initial aggression faced.
What was the aggression on the part of the man who steps in between the woman and Mr. McRae?
I think it is the stepping in front and colliding with him, Your Honor. I think AC is causing the collision by getting between Mr.
Well,
McRae.
I understand your argument that it causes the collision. I'm a little less clear on why that constitutes an aggressive behavior. Why couldn't well, I'm wondering if you have additional evidence that it was aggression.
I think it's not necessarily about whether those appearances were true, Your Honor, about whether that was actually aggression. I think it's about Mr. McRae's reasonable
Perception, fair.
So once he, runs into AC and they collide chest to chest, I think that's what he perceives as aggression. And that's what the question is whether in response to that belief, he responded reasonably. And I think at that point, again,
Why wasn't it an act of gallantry and defense of others on the part of this gentleman to step in front of his lady friend?
I think you could
Put this in
certainly,
medieval terms.
you can read it that way, Your Honor. I think defense counsel sort of points this out in closing, that you can believe everyone's actions were reasonable here. It is totally reasonable that Mr. AC may have.
Well, there's
perceived
one
this-
problem with that. It's not, it is hard to see how it's totally reasonable for Mr. McRae to start running at and, whoever he ran at.
I think that Mr. McRae is running the entire time, Your Honor. I think that's the context of this scenario, is every time these parties see Mr. McRae.
What's he trying to do?
I don't think that evidence,
You think he was going to draw up to a halt and say, "Madam, I insist on an apology"?
I think that the testimony, Your Honor, is that consistently every time they see Mr. McRae, he runs towards them. They sort of see it as a near miss, but he avoids them every single time because he's running a direction that they believe is the opposite direction of what he's supposed to be running. They say he's on the wrong side of the trail. As defense counsel points out, there's no law that says what side of this trail you can run on or can't run on. So he's running on the trail and they believe that he is avoiding them, that he's near missing them. But that's the context of this.
Is there a line on the trail?
Sorry?
Is there a line on the trail that divides?
I believe there is some testimony, Your Honor, that there is a line. I would have to check the transcript and I'm happy to do that.
Because there might not be a law about what side, but there might be a strong presumption of what side you would be on.
There
If
could
you're
be, Your
riding
Honor.
bikes or running,
I think all you have is AC's testimony that this is a bike trail and that he thinks that he's running on the wrong side of the trail. I don't know that anyone introduces photographic evidence of what's going on here and what this trail looks like. I think the only photographs are the evidence that are.
By the way, did Mr. McCrae did not suffer any injuries, I take it?
There's no testimony about any injuries, Your Honor, on the record. I think to go back to Your Honor's question about reasonable force, it does have to be completely disproportionate. And I think that once Mr. McRae perceives that there is this collision and that someone has physically contacted him, his response is to hit several times and then leave. And that is the testimony, is that all of this happens within 1 minute, is MH's testimony. It's not a prolonged hit. There are lots of cases that talk about what is completely disproportionate. All of them do involve sort of knocking people to the ground, punching them unconscious, dragging across broken glass, hitting people with weapons, shooting them. Those
That's
are
where I'm hung up a little bit, is the absence of evidence that McCrae reasonably felt he was in danger.
So, Your Honor, I take it that you are sort of referring to the fact that the trial court discredits Mr. McRae's testimony about his fear.
Yeah, well, I mean, I guess right. I mean, I guess you could put it that way.
So I think that the fact that the trial court, when it is making its analysis, ignores the collision sort of defeats the fact that the judge could reasonably find on these facts that Mr. McRae didn't have a reasonable belief, that it was disproven by the government.
Your argument, I guess, is based on the notion that McCrae could not stop himself.
You mean as he's running, Your Honor?
Once he starts running, which seems like an aggressive act, by the way, but once he starts running directly at this woman, your argument turns on the notion that he could not stop himself and avoid the collision with the person he collided with.
Given how fast this happened, Your Honor, I don't think it's possible he could have, and he couldn't have anticipated that AC was going to get in his way. I think as he's running, AC gets in front of him. That's something he doesn't have control over at that point. AC is purposefully doing it, and granted, I understand that the court may find that that was perfectly reasonable on AC's part.
I suppose that if AC had not done it, and if it's really true that Mr. McCrae could not stop himself in time, Mr. McCrae would have run into the woman. He wouldn't have been able to stop himself from running into the woman either.
I don't think we know that, Your Honor. I think that
Is it a fair inference that the judge could draw?
I don't know that it is. I don't think there's testimony about where they are at that point. I think MH, and we point this out, I think, in the brief, MH later, as she's testifying, admits that she was not actually facing the direction of AC when all of this happens. She was turned the other way. So she doesn't testify about how far away she was. I don't think she knew how far away she was when AC sort of stepped back and got in the way. I don't think there's any information that would allow us to say how close he was.
So one way to look at this is if Mr. McCrae recklessly decides to charge at the woman, the fact that somebody gets in the way to protect her is something he can't argue, oh, I've been assaulted as a result of that collision. He's the one who set this thing in motion.
I don't think he's arguing he was assaulted, Your Honor. I think it's that he, at the moment that it happened,
Right.
perceived.
I said that a little bit imprecisely, that he needed to use self-defense to protect himself from the person who.
Yes, Your Honor. I mean, as I've said, I would dispute that charging is the right word. I don't think that's what the trial court found, and I don't think that's what the record reflects. I think it was running. I think he was running towards them. That's what he had done at every encounter he'd had with these individuals. AC testifies on the record that he's running at the exact same speed that he had run earlier.
Yeah, but this is different because in all those other occasions, he's running away from the person, from the people. He's sort of passing them by. Whereas in this case, he's already passed them by, and because he's offended, I guess, by the name calling, he turns around and says, I'm coming at you.
I'm coming back, Your
Back to
Honor.
you, yes.
I'm coming back, which I think is.
Sounds a little threatening, right?
I don't think it's a threat, Your Honor. I think he says he's coming back. I think this is not a sneak attack. This is not like he's ganging up on them. I do think the case law says it's important that there is a group of people versus Mr. McRae when he reasonably perceives this. I think that Parker is the closest case to that, and it's not exactly on point, but there's 3 people and a dog versus Mr. McRae. And so when Mr. McRae comes back and
I hate to ask, where was the dog in all this?
Honor, the dog is the subject of much dispute at this trial, and where the dog is and whether the dog was actually involved in the altercation. I think that reading the evidence in the light most favorable to the government, the dog is walking in front of the parties, and the parties are walking all shoulder to shoulder down the trail.
So this is a failure of the dog to come to the aid of its master. Oh, all right.
Is it a
Interpret
good
it that
dog?
way. I will not slander the dog by discussing what the dog did.
Thank you, Ms. Carter. We'll give you a couple of minutes on rebuttal. We'll hear from the government.
May it please the court, Alan Darby for the United States. This court should affirm James McCrae's simple assault conviction because sufficient evidence supported it, and appellant's claims of errors on appeal are without merit. As appellant focuses their argument solely on the issue of self-defense, I will principally consider that and argue on that, and will defer to our brief on the other issues unless the court has other questions, then I would be happy to answer. Your Honors, it's black letter law from this court that the trial court's credibility determinations alone is enough to defeat a claim of self-defense. And here, the only thing supporting McCrae's theory of self-defense was his testimony. And so that's Davis versus United States, and I think that could settle the issue there. If you want to get into the exact issues or factors considered in self-defense, the trial court found that in the October 7th transcript at 110 to 111, that no reasonable person could conclude that Mr. Correa posed a danger. Mr. Correa testified that he made no offensive move ever during this incident, and even McCrae testified in his case, in the defense's case, that Correa never raised his hands and never tried to punch him. And so I don't think there's any evidence in the record that would show that a reasonable person would conclude that Correa was posing a danger. And even I would point your honors to McCrae's description of the event where he says that Correa, and this is at page, brief indulgence, your honors, I apologize. This is at page 73 to 74. McCrae described Correa's lunge as a, quote, stereotypical frat boy or an athlete kind of way, a testosterone-filled athlete in a way where there's a wrestling match or a headbutt where 2 people get in front of each other. I'm not quite sure exactly what McCrae is trying to describe there. It certainly seems incoherent, but I don't think it would justify a reasonable apprehension of imminent harm. Even assuming there was a reasonable apprehension of imminent harm, the trial court appropriately found that this was excessive force because by McCrae's own testimony, there was no punch, there was no offensive move from Correa's testimony. What does McCrae do in response? He throws an Ali blow, his words, an Ali blow at Correa, and is swinging at everything above his shoulders, and he's leaving from Government's Exhibit 1 to 5, multiple redness marks, a red mark on his chin where MH testified that that's where McCrae punched him. This wasn't a reasonable use of force where appellant now concedes at oral argument. McCrae suffered no injuries. And at trial, there was never any evidence or testimony that McCrae suffered any injuries. But even
Did she concede that, or did she just say there's no evidence in the record?
I think it's both. I think she acknowledged when she was before the court that there was no injuries from McCrae. I mean, I will also say there is no evidence of McCrae's injuries at the trial court. So I don't think that's of any moment, but I think Your Honor is correct that the distinction is important. But even
Is there evidence that Mr. Correa, is that how you're saying it?
I believe so with the accent.
Suffered injuries consistent with an Ali blow?
Yes, Your Honor. So, and this was also a dispute about sort of the inherent credibility argument from appellant, where they tried to say it was inconsistent or inherently incredible that MH said there was a punch, but she did not see the punch, but she made a reasonable inference because she heard the sound of an impact. And when she looked at Mr. MCRAE previously, there was a red mark on his face consistent with a punch. But even assuming that there was not an excessive use of force, MCRAE was the first aggressor here. And I think the trial court found that on page 111. The trial court said that MCRAE might have been in danger of running into someone, but you can't punch the guy that you're actively running towards and causing this collision or this incident. And so I think even if this court were to do a self-defense analysis, absent the credibility determination, the self-defense argument by appellant really has no merit. And if there are no further questions from the court, we would respectfully ask this court to affirm. Thank you.
Ms. Carter, we'll give you a couple of minutes.
So, Your Honor, just a couple of points. I think that the government really heavily relies on the fact that there's no injury to Mr. MCRAE. I don't think the case law requires that there be an injury to Mr. MCRAE. I think Mr. MCRAE has to perceive that he is in danger, and it has to be reasonable. We don't have to wait for someone to be injured for them to invoke self-defense. I think that would defeat the purpose of self-defense if we say you must be injured before you can react and defend yourself. So I don't think that that has any bearing on whether or not Mr. MCRAE it's relevant for the court to analyze whether or not there were injuries. But I don't think it's dispositive in the way that I think the government says it is. And I think that the court's correct that Mr. MCRAE did not testify about injuries. He doesn't have to, would be my position. I think that the force, the case law is not perfect in sort of making a case-to-case comparison for this. But the case law does say it has to be completely disproportionate. And it's my position that when you collide with someone and you have made physical contact at that point, to hit someone several times and then get away from them is not a completely disproportionate reaction to the fact that you have made the collision with them, particularly in light of the fact that this is all happening very quickly. This is all happening in a very small amount of space. Mr. MCRAE cannot control AC's actions. He can't control the fact that AC got in front of him. And he is reacting to the immediate circumstances that are happening to him. So I do not believe that hitting someone several times and then leaving, which the case law says is relevant to a self-defense claim, is completely disproportionate in this case.
By the way, I think I understand that this was a case that was handled by the clinic at GW, and I think we should thank you and the clinic for taking the case on.
Yes, Your Honor, and I'd certainly like to thank the students who drafted this brief, Maggie Diaz and Mia Schaefer, who are both studying to become members of the bar currently and were not able to do this argument. I wish they had been able to, but they are, I believe, streaming the argument. So I'd like to thank them for their excellent work. There are no further questions. Thank you, Your Honor.
Very much. Thank you to both sides for your briefing, as Judge Glickman said, and your arguments today, and the case will be submitted.
All rise.